Hi, my name is Steve Zeiger. Over the past several years, we've been asked to educate members of NAPAC, the National Association of Estate Planners and Counsels, STEP, the Society of Trust and Estate Practitioners, over 30 local estate planning councils, over 10 FPAs, the Practicing Law Institute, the CFA Society, and we've been speaking about the fiduciary era for life insurance. We've had so many requests for the presentation, we decided to put together an educational video so you can have a copy of the presentation and you can have our verbiage in the background. And now's actually the perfect time to educate fiduciaries on the proper decision support material for life insurance, because on October 20th, 2022, the New York State Court of Appeals constitutionally affirmed Regulation 187, the nation's first client's best interest regulation. A little bit of housekeeping before we begin. If you have a question, you can email me. My telephone number is on the screen. If you'd like a copy of our Trust and Estates article, simply send me an email. We're happy to send it to you. And if you'd like a research report at no cost, again, simply email us or call me on my phone. It doesn't mean we're doing business together. If you have a request, it simply means you'd like to learn more. Now let's talk about litigation regarding life insurance. And there are two cases that I think are important to discuss today. The first case is Nacio versus Goldman Sachs. And probably remember the name Nacio. He was chairman of Quest Communications. And you might recall that he was arrested on running a $3 billion fraud. He spent 4 years in jail, and his fine was, I think, $60 million. Well, Nacio purchased a life insurance policy from ACO, a division of Goldman Sachs, among the smartest financial minds on the planet. And the advisors at ACO breached their advisory duties, so they didn't look at some of the things that we've been speaking about today. And Joseph Nacio won a $14.1 million judgment against Goldman Sachs ACO. And what's very interesting about this case is usually I'm presenting to attorneys and accountants and RIAs, and I say to the attorneys, how much credibility does a convicted felon have in court? And they always reply, none. So imagine this, a convicted felon sues Goldman Sachs ACO, among the smartest financial minds in the world, and wins a $14.1 million lawsuit. So most of our clients and most of your clients are not convicted felons, and that really teaches us why we should be careful in how we present life insurance. Let's also speak about Cochran versus Keybank. So Cochran versus Keybank was a very interesting case because it was the first adjudicated lawsuit regarding a life insurance policy owned by a trust under the Uniform Prudent Investor Act. So the facts of the case are as follows. Cochran owns $4.5 million of general account product. So that's either whole life, universal life, or an annuity. Later, Agent Robertson suggests a change to an $8 million variable life contract, and Grantor Cochran moves to the $8 million contract. Years later, Agent Robertson communicates to Grantor Cochran that if the stock market goes down, Cochran can lose his entire death benefit and all of his cash value. Cochran responds that he doesn't want his legacy subject to the stock market, and in addition, he can no longer afford to pay premium. So Agent Robertson suggests a $2.5 million paid-up contract, and Keybank hires an independent third party to interview Grantor Cochran and the trustees at Keybank Trust Company, and they opine that this transaction makes the most sense for Grantor Cochran. They move ahead with the transaction. Cochran is 53 years old, so he should have a life expectancy of another 30 years. And I don't remember if the exact words were the case where he unexpectedly died or he died unexpectedly, but 6 months later, he passed away. And the family lost the difference between $8 million and $2.5 million, a $5.5 million loss. They sued Keybank under the Indiana Uniform Prudent Investor Act, and the court decided that because Keybank went to an independent third party that had no financial stake in the outcome, that was considered a safe harbor under the Uniform Prudent Investor Act. So Trust and Estates magazine asked us to review the case using independent research, and I'll show you how we did that in several more slides. But what the independent research showed was The internal costs of the $8 million contract per $1 million of death benefit were lower than the internal costs of the $2.5 million contract per $1 million of death benefit. Had they simply moved the death benefit from $8 million to $5 million and transferred the cash value from a stock market-based fund to a money market fund, they could have had $5 million of coverage going forward. Now, many insurance agents, when they hear the story, they say to me, "Hey, Zeiger, we don't really like this independent research model so much. You just ruined the sale for us." And what they fail to see is that when you are transparent, when you disclose all costs, when you use independent research, people will beat a path to your door because you're helping them achieve a better outcome with all of the information available.